This case starts with what seems like a routine landlord-tenant dispute, but within seconds, it spirals into procedural chaos. A landlord files another case, thinking it strengthens her position, but instead, it completely derails the courtroom. Now the judge is left trying to untangle overlapping filings, escrow confusion, and conflicting claims, all while both sides dig themselves deeper. The big question is, was this a strategic move, or a costly mistake? Because as you're about to see, one wrong legal step can turn a strong case into a complete mess.
I'm a bit confused about one thing. Ms. Anderson, you filed a new case for non-payment?
Yes, that was just to make sure for,
Make sure of what?
she hasn't paid, September, October, or, rent, so. I was told to file a 7-day.
Did you put September in escrow?
No, I have not.
When are you gonna do that?
This Friday.
This Friday. And then what about October?
I'm gonna get that in as soon as possible as well. I don't have a deal.
So
I thought I was supposed to,
what?
sorry.
What did you say?
I thought I was supposed to, since she was late for rent for 3 months.
Well, if I render a decision on this case, something's gotta be done with that one because this is a non-payment also.
Yeah, it is, sir. I'm sorry.
When is that set for?
November 7th.
That's the 8:30 hearing.
Yes.
My date after that is in what?
It's
No, no, this for Tuesday. So here's what I'm gonna do. That case, have you been served on that case, ma'am? A new one
So yes.
to come to court on the 7th?
Yes.
All right. I don't know why that was done, but it's now caused a bit of confusion. It's procedure. Yes.
I thought I was supposed to when it was late. I'm sorry if I made a mistake, but
Well, there's an escrow order that's in this case. And you went through a whole hearing on this case.
yeah.
And I'm gonna render a decision, but that other case is outstanding. So what I'm gonna do is I'm gonna let that proceed on the 7th. I'm gonna adjourn this case to, my decision on this case to November 18th to allow that case to catch up because I don't want a stray case out there. You have the option if you want to, I'm still adjourning this one out to that date, but you do have.
This is where things start to fall apart procedurally, and the judge sees it immediately. What the landlord did here is a classic mistake, filing a second non-payment case while an escrow-based case is already active. In legal terms, that creates overlapping jurisdiction and risks conflicting rulings. The judge isn't just confused, he's concerned about maintaining order in the court. Notice how he shifts control by adjourning the decision instead of rushing forward. That's intentional. He's preventing what could become a legal contradiction later. But here's the real issue. If you were in this situation, would you try to double down like the landlord did, or stick to one clean case and let it play out?
The option that what you can do is you can dismiss that other case because I don't know what you would get out of that case that you wouldn't get in this case.
Can I dismiss the?
I don't have it in front of me. I don't even know why you filed it.
Can I dismiss this case and just go with this one on the 7th? Since it's for non-payment of rent? That's what I prefer to do.
I'm not gonna relitigate this whole case.
I just
That's
want,
what you wanna do.
no, I just want to do it for non-payment of rent. I can dismiss the first case and just,
Well, she's got some counterclaims. You wanna just dismiss this case and just go forth on?
We'll keep going. We've been here since June, so.
Oh, I know.
I mean, there's also an outstanding water balance of almost $1,500. So I would just rather cancel this case since I'm the plaintiff and then just go with the 7th.
Yeah.
The water bill she mentioned, she took the water bill out of my name and paid it in full.
It was due on the 6th and they said it would go on my tax bills if I didn't pay
I
it.
don't know why I'm talking about a water bill at this point.
Sir,
What do you want to do? Because you've got this thing all over the place.
I'm gonna I'm going to withdraw this case and just go with the 7th for non-payment of rent. She's 3 months behind right now. And the water bills,
How can she be 3 months behind? She's,
September, October, and then it'll be November, and then the water bill of $1,500. So it's well over, she owes a total of $15,000, a little over 15, and she has 6,600 in escrow. So it's getting deeper and deeper. The further we delay it, the bigger the hole gets.
I'm not delaying anything. You keep doing stuff.
I want to withdraw this one and just go for the 7th since I'm the plaintiff on both. For non-payment of rent, that's all I'm concerned.
No, I know. That's why I don't understand the second case.
Well, that's all I want is the.
I mean, you think I'm sitting up here and don't know anything.
Yeah.
I look stupid, but I'm,
No, you're very smart, sir.
oh, I know that.
I would just rather withdraw this case and just go on with the 7th.
You let me know when you're done talking.
Okay, sir. Thank you, sir.
Are you done?
Yeah, I mean, the other attorney
Apparently not. Go ahead.
the other attorney I was working with before suggested that I do that I withdraw this case and just do the 7-day notice. That's what he suggested. He said that would be easier.
You done?
Yes, sir.
Lyman, what would you like to do? So just so that you understand, if she dismisses this case, what I would do is I would pay the escrow over to her, okay, on this case. Now, no, if you dismissed it, I wouldn't be dismissing any of your claims that you have against her. I wouldn't be dismissing any of them with prejudice. You'd be able to raise them in the other one if that's what you choose to do. But that's up to you. And then you'd have to come back on the 7th and we'll see exactly where we are.
I just feel like we should just keep going because this one.
But
Finish it out.
since I'm the plaintiff, don't I have the right to cancel that one, listening to my counsel?
You should have gotten an attorney before you started.
I
But
know, but that's what he suggested I do. He said,
no, because once she's answered, she has the same right. She can say no.
okay. So if I cancel the one on the 7th, can we just be done with this today? Is that better? I just don't want to keep dragging this on. So if I just kill the one for the 7th and we just,
Ma'am, I can't give you.
well, that's what I want to do.
As to, well, I don't have that case in front of me. It hasn't even been heard. It was filed.
It was just for non-payment of rent, but since you said it overlaps this one, then let's just cancel that one and just do the non-payment of rent on
Here's
this.
what I'm gonna do. You're gonna stop talking,
Okay,
and then I'm gonna do what I was gonna do at the beginning. And that is, I'm gonna let that other case catch up. They're just gonna be together because you elected to file it. Whether, under what reasoning, I'm not even concerned about that. But I'm not gonna have two cases standing out in this situation. So I'm adjourning this case for its decision to November 18th. When we get to the other case on the 7th, I will try to have that case catch up with this case. And then we can just decide everything, unless somebody wants to file something else in the interim. Thank you.
thank you.
What time on 18th?
9.
Are we coming on the 7th as well, sir? Okay. Thank you.
You know what? And my good friend, Mr. Lloyd, was sitting there and he wouldn't help me. He just sat there. Just sat there and watched me flail. Nothing like having friends. Did you see that? You did. Yeah, I did. I did too, Joe. Court calls the case of the people versus Gabriel Shawaka.
The water assistant prosecuting attorney for the people.
Seeing some of that happened in Shapiro, Shalaka. Present to my right.
State your name, sir.
Gabriel Schwab.
All right. Set for a preliminary examination. Are we ready to proceed?
Yes, Your Honor.
People are ready, Your Honor.
All right. Let me call you first witness.
Your Honor.
Your Honor, first, I'm asking first, sequestration.
Easy. You just said.
Easy for me to say.
In the end, what we saw wasn't just a rent dispute, it was a breakdown in legal strategy. The landlord believed filing an additional case would strengthen her position, but instead, it created confusion, delayed judgment, and weakened the clarity of her claims. The judge stepped in to restore structure, making it clear that the court won't allow multiple overlapping cases to muddy the process. Meanwhile, the financial stakes kept growing, rent, escrow, and outstanding balances all piling up as time passed. This case is a perfect example of how critical it is to understand procedure, not just facts. Because in court, how you file can be just as important as what you're claiming. Backhand index pointing right. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.